Good morning. Continuing with our video presentations, this morning we're going to cover public arrest. We're going to cover the Louisiana statutes that's dealing with public arrest and also the constitutional cases that deal with public arrest. We'll also cover arrest in the home, and then we'll move on to administrative inspections. This will be a very short video. So these areas are not difficult to learn. They're not difficult to understand. They're just kind of technical areas that you need to understand and sort of give you a better overview of how criminal procedure or how the Fourth Amendment works. We're going to start off with public arrest. And we're going to start off with the case of United States versus Watson. In United States versus Watson, confidential informant provided officer with information on stolen credit cards. At the command of the officer, the confidential informant met with the defendant to acquire a stolen credit card from him. The meeting was arranged. The confidential informant signaled the officer that he had purchased an additional credit card or had purchased additional credit cards. The defendant was arrested. No cards were found on him, but 2 credit cards were found in his nearby car under the floor mat. The question became, could the officer actually arrest this person without a warrant? Here, he had noticed criminal activity, and what he believed to be criminal activity occurred in his presence. However, he did not have a warrant to arrest the person. And again, the question became, did he need a warrant to arrest? The code says, I'm sorry, not the code, but the case says, a peace officer is permitted to arrest without a warrant for a misdemeanor or felony committed in his presence, as well as a felony not committed in his presence, if there was reasonable ground for making the arrest. The Fourth Amendment permits a duly authorized law enforcement officer to make a warrantless arrest in a public place, even though he had adequate opportunity to procure a warrant after developing probable cause for arrest. The officer did have the question becomes here, when we look at United States versus Watson, that the officer had the opportunity to obtain an arrest warrant before the arrest based on the information that he received from the confidential informant. The answer is yes. He had credible information from a credible informant that the person was selling credit cards, and thus he could have received a warrant. But the case says that he did not have to receive the warrant, or he did not have to acquire a warrant before he could make a public arrest. The only thing that was required is that he had probable cause to believe that criminal activity had occurred. And here he had probable cause to believe that criminal activity had occurred. A criminal activity occurred in his presence, whether it's a felony or a misdemeanor. It doesn't matter as long as it is an arrestable offense. That's what's important here, that he can make a public arrest for any offense that occurs for which he has probable cause, as long as it is an arrestable offense. Now, there's another question that comes up after the public arrest is made. Officer believes that he has probable cause to make an arrest. And he makes that arrest. He makes that arrest without a warrant. He makes a public arrest. What happens after the officer makes the public arrest? Before I go there, let's look at the Louisiana Code of Criminal Procedure, Article 201. It defines an arrest. An arrest is the taking of one person into custody by another. To constitute an arrest, there must be an actual restraint of the person. The restraint may be imposed by force or may result from submission of the person arrested to the custody of the one arresting him. Now, Article 213 deals with arrest without a warrant. A peace officer may, without a warrant, arrest a person when person commits an offense in the presence of the officer. If it is a misdemeanor, it must be made immediately or in hot pursuit, that is the arrest. Person committed a felony. Officer had reasonable cause to believe that the person to be arrested has committed a crime, and reliable and positive information that another officer of the state has a warrant. Now let's move on. Once the arrest is made, then what happens? Let's take a look at the county of Riverside versus McLaughlin. The county of Riverside versus McLaughlin, the question became, again, what happens after the person makes an arrest? In Louisiana, it is required that after an arrest is made under 230 on the Code of Criminal Procedure, Article 230.2, that there must be probable cause must be found by the magistrate. What happens? The arrest is made, and then after the arrest is made, the person filed, or the person who makes the arrest, that is the officer who makes the arrest, files an affidavit of probable cause with the court. Once they file that affidavit of probable cause with the court has to come in, judge has to come in and look at that affidavit of probable cause and determine whether there's actual probable cause for the arrest that has been made. Riverside versus McLaughlin deals with how much time or when does a judge have to make that probable cause decision when there's a public arrest without a warrant. And what Riverside versus McLaughlin said, the court held that states must provide a fair and reliable determination of probable cause as a condition for any significant pretrial restraint of liberty. And this determination must be made by a judicial officer either promptly before or promptly after the arrest. That is, the probable cause decision of a public arrest is initially made by the officer. However, it must be confirmed by a judicial officer. And when I say the officer, initially made by the officer, initially made by the police officer who conducts the arrest. Now, how long or what is the time period that is necessary to conduct this probable cause hearing? The court said that it must be reasonable. It said, and it talks about Gerstein. It said, because Gerstein permits jurisdiction to combine probable cause determinations into other pretrial procedures, some delays are inevitable, as long as it's reasonable. There may be a reasonable postponement of probable cause determination while the police cope with the everyday problems of processing suspects. Also, jurisdictions may choose to combine probable cause determinations with other proceedings. They may do so as long as they do so promptly. Excuse me, I apologize. Thus, only those proceedings that arise very early in the pretrial process, such as bail hearings and arraignments, may be chosen. Therefore, the length of time in which the court has to conduct this probable cause hearing, again, it must be reasonable. And when I say the court, that is the judge, must conduct the hearing to determine whether the officer in the field had probable cause to make the arrest. It must be reasonable. But the reasonableness can be based upon several things. What is necessary to carry out the booking process? Not only what is necessary to carry out the booking process, that they can combine these hearings, these probable cause hearings, with other pretrial proceedings that are promptly held, a bail determination or an arraignment. They can be combined, and thus the court are going to say that they are reasonable. However, the court set a parameter. They set a parameter and said that it is reasonable, is prompt, and we're going to presume that it's reasonable if it's made within 48 hours. If it's made outside of 48 hours, the state will have to show that it was reasonable, that it was a part of a necessary process of booking, or that it was a part of a pretrial process, a necessary pretrial process, and did not unnecessarily delay the probable cause hearing. Louisiana has adopted that. If you look at Article 30.2, Code of Criminal Procedure, Article 230.2, we've adopted the 48-hour rule. That is, a probable cause hearing must be held within 48 hours. And generally, that probable cause hearing is combined with the bail, setting of the bail. And the way that it generally happens is that the person is arrested, he's taken downtown, or he's taken to the local parish prison, and there's a video conference or a video presentation with the judge, and the judge would tell them his charges, read the charges to him, basically read the probable cause affidavit, the reason why he was arrested, and they will set bail at the same time. That is the probable cause hearing. It is not the arraignment. The arraignment in Louisiana must take place within 72 hours. The probable cause hearing within 48 hours, but the arraignment takes place within 72 hours. And sometimes the arraignment or the probable cause hearing will be combined with the arraignment, but generally they are separate. They are separate determinations. If the person believes that even if the probable cause hearing is held within 48 hours, that it could have been held earlier, it could have been more promptly, in order to meet the requirements of the Fourth Amendment, then he has the burden of showing that it's the defendant who says that, hold it, they unnecessarily detained me, and they could have held this probable cause hearing within less than 48 hours. He has the burden of showing that that there was an unreasonable delay, that it was motivated by ill will. That is, that there was some animus on the part of the state. Moving on from the public arrest, and let me read to you Article 230.2. A law enforcement officer effecting an arrest of a person without a warrant shall promptly complete an affidavit of probable cause supporting the arrest of the person and submit the same to a magistrate. The first thing you want to do, if you're representing somebody, get a copy. If it's representing someone in a criminal trial, I should say, get a copy of the affidavit for probable cause. That's going to help. That's going to serve you greatly. Persons continued or remaining in custody pursuant to an arrest made without a warrant shall be entitled to a termination of probable cause within 48 hours of the arrest. The probable cause determination shall be made by a magistrate and shall not be an adversary proceeding. The determination may be made without the presence of the defendant and may be made upon affidavits or other written evidence. A magistrate's determination of probable cause hereunder shall not act as a waiver of the person's right of a preliminary examination pursuant to Article 292. Thus, 48 hours is the requirement under our law, and the determination will be made by the judge and is not an adversary proceeding. With that, let's move on to, if we will, let's move on to the arrest in the home. Arrest in the home. The primary case when we talk about the arrest in the home is Payton versus New York. And Payton versus New York detectives had evidence to establish probable cause to believe that Mr. Payton had murdered the manager of a gas station. And what they did, they went to someone else's home for the purposes of arresting Mr. Payton. Let me read the facts to you. New York detectives assembled evidence sufficient to establish probable cause to believe that Payton had murdered the manager of a gas station. At about 7:30 a.m. on January 15, 6 officers went to Payton's apartment in Bronx intending to arrest him. They did not have a warrant. They did not have a warrant to arrest Mr. Payton. Although light and music emanated from the apartment, there was no response to their knock on the metal door. They summoned emergency assistance, and about 30 minutes later, with used crowbars to break open the door and enter the apartment. No one was there. In plain view, however, was a .30 caliber shell casing that was seized and later offered in evidence at the murder trial. On March 14th, a person named Riddick was arrested for commission of 2 armed robberies that occurred in 1971. They did not. He had been identified by the victims, and these are 2 combined cases. They did not obtain a warrant for his arrest. At noon on March 14th, a detective accompanied by 3 other officers knocked on the door of Queen's house where Riddick was living. When his young son opened the door, they could see Riddick sitting in the bed covered by a sheet. They entered the house and placed him under arrest. Before permitting him to dress, they opened a chest drawer 2 feet from the bed in search of weapons and found narcotics. Basically what's happened in both of these, they went to the home without an arrest warrant. They went to the home without an arrest warrant for purposes of arresting the person. The court said, in an instance where officers have probable cause to believe that a person has committed a crime, and they go to the person's home, and they don't have an arrest warrant. Is what happened in both of these instances. It is a basic principle of Fourth Amendment that search and seizures inside a home without a warrant are presumptively unreasonable. Absent exigent circumstances, a warrantless entry to search for weapons or contraband is unconstitutional, even when a felony has been committed and there is probable cause to believe that incriminating evidence will be found within. If there's sufficient evidence of a citizen's participation in a felony to persuade a judicial officer that his arrest is justified, it is constitutionally reasonable to require him to open the doors to the officers of the law. Thus, for Fourth Amendment purposes, an arrest warrant found on probable cause implicitly carried with it the limited authority to enter a dwelling in which the suspect lived when there is reason to believe that the suspect is within. Because no arrest warrant was obtained in either of these cases, the judgment must be reversed. Basically, what the court is saying, that in order to enter a person's home, in order to arrest him, you have to have an arrest warrant. Even though you have probable cause to believe that has been engaged in a crime, that in order to arrest him in his home, you need at least an arrest warrant. But the arrest warrant, and it's very interesting what the court says here, the Fourth Amendment. Thus, for Fourth Amendment purposes, an arrest warrant founded on probable cause implicitly, and so if he does have an arrest warrant founded upon probable cause, carries with it the limited authority to enter a dwelling in which the suspect lives when there is reason to believe that the suspect is within the dwelling. And so you have to reasonably believe, or the officer has to reasonably believe that the suspect is present. And they have to show within, when they execute this, that it was reasonable to believe that the suspect was present on the premises. Otherwise, that, even though they may have that arrest warrant, that entrance is going to be unreasonable. It will be unreasonable. And so the basic premises for under Payton is that you can arrest a person in his home if there's probable cause to believe that he's involved in a crime. However, to arrest him in a home, you must have at least an arrest warrant, and there must be reason to believe that he's present at the time that you're going to execute that arrest warrant. Now let's move on. And Louisiana followed that route. Now, in order to arrest a third party, arrest a third party whom you believe has been involved in criminal activity, of whom you have evidence that this person has been involved in criminal activity, and someone else's home, or arrest a suspect in someone else's home, what is required? What is required when you go into someone else's home to arrest a suspect? Is an arrest warrant enough? I'm going to a third party's home. The person is there. Now, is an arrest warrant enough in order to arrest that person? Let's look at Minnesota versus Olson. In Minnesota versus Olson, they went to Olson's apartment to arrest Olson, but he wasn't there. But they got information that Olson was somewhere else, and Olson was an overnight guest at someone else's home. So the question became, and they only had an arrest warrant in order to arrest Olson. And so the question became whether an arrest warrant was enough for the purpose of arresting Olson in someone else's home. The court says Olson status as an overnight guest alone is enough to show that he had expectation of privacy in the home that society is prepared to recognize as reasonable. To hold that an overnight guest has a legitimate expectation of privacy in his host's home merely recognize the everyday expectation of privacy that we all share. And so if you are an overnight guest in someone else's home, if you're an overnight guest in someone else's home, you have a reasonable expectation of privacy in that person's home. Thus, in order to arrest you in someone else's home, if you are an overnight guest, then you have they must have an arrest warrant. But is that all that is necessary? Staying overnight in another's home is a long-standing social custom, explaining why they must have at least an arrest warrant. Long social custom that serves functions recognized as valuable by society. We stay in other homes when we travel to a strange city for business or pleasure, when we visit our parents, children, or more distant relatives out of town, when we are in between jobs or homes, or when we house sit for a friend. We will all be hosts, and we'll all be guests many times in our lives. From either perspective, we think that society recognizes that a house guest has a legitimate expectation of privacy in the host's home. Thus, he has a legitimate expectation of privacy. And so in order to arrest in the home, again, you need at least, and he's an overnight guest, at least an arrest warrant. However, you're going to need, in addition to an arrest warrant, because it's someone else's home and you're invading the sanctity of someone else's home and someone else who lives there, not just overnight gas, that you need also a search warrant in order to arrest the person whom you have probable cause to arrest. And so if it's in the home, if the suspect is an overnight guest in the home of another person, you're going to need an arrest warrant and also a search warrant. However, what if he's not an overnight guest? What if he's not an overnight guest? If you look at Minnesota versus Carter, he was there for the purposes of involving in criminal activity. He was there for the purposes of cutting drugs and distributing drugs and making a drug transaction. And so the court had to make a determination as to whether he had standing in order to say that they needed an arrest warrant in order to make an arrest in the home. The court said no, no arrest warrant was required. They did not need an arrest warrant in order to make the arrest. Did not need an arrest warrant because he was not an overnight guest. He was there for the purpose of a business transaction, and thus he was only a temporary guest. And so if he's a temporary guest, he doesn't have standing to say that they did not have a warrant to come into the home. He doesn't have standing to say that they need an arrest warrant. They have probable cause for the purposes of arresting him there in the home. However, again, the person of the owner of the home can make the allegation that they need, or can make the allegation that in order to come into his home, they need a search warrant. Now, what will happen here? They come into the home, let's assume that they have probable cause to believe this person has, and they know that the person was involved or is involved in criminal activity. They come into the home to arrest not the owner of the home, but to arrest the person who's there, who is not an overnight guest, who doesn't have a reasonable expectation of privacy. Now, we said that they're going to need, they will not need the arrest warrant, but for the purposes of the homeowner, they will need a search warrant. However, any evidence that is found in relation to the person for whom they have probable cause to believe he's engaged in criminal activity will not be quashed on the basis that they made an illegal entry into the home, because that person does not have standing to complain about the illegal entry in the home. Only the homeowner has standing to complain about the illegal entry to the home. And so if the homeowner can complain, he can file an action if there's some damages. If there's some damages that he can obtain from that illegal entry. Thus, at this particular point, I'm going to quit because I'm at 22 minutes. I promise you it will only be 20 minutes. And what we will do on Monday, I will pick up and I will start with what is it, Cameron, New York versus Cameron. We'll take that very short principle I want you to get from there, and then we'll go into Terry. And on Monday, we will cover Terry, and we probably spend most of the time covering Terry, and we might get to some of the application of Terry cases such as Adams versus Williams, Pennsylvania versus Mims, and Maryland versus Wilson. That's probably as far as we will get. I know that you don't have Pennsylvania versus Mims or Maryland versus Wilson, but I will post information on those two cases for you on the website. You can take a look at them. So we'll see you all on Monday. Have a great weekend. Thank you.